Good morning, Oregon. My name is BJ Soper, and I wanted to take a few minutes here to create this video to basically show the people of this state, the businesses within this state, that the executive order that has been given to us by Kate Brown is unconstitutional. I think we can all read, we can all understand, simple English language, and I'm going to show you today that not only does this executive order violate one article of the Constitution, it in fact violates it 9 separate times. So I hope this information will be super useful to you. I'm hoping that it will give you the courage to stand up for yourself, to stand up for your business, to open your business, restore your life back to the way that it needs to be. This information comes with a statement from our Supreme Court on our authority and ability to ignore unconstitutional law. And that's where I want to begin with you guys today. So I'm going to read this short ruling that the Supreme Court gave. It is recorded in the 16th American Jurisprudence Edition, the second edition, and you can find it in section 177. And in the latest second edition, it's section 256. So it speaks on the topic of duty to an unconstitutional law. And I'm going to read it word for word, so bear with me here. The general misconception is that any statute passed by legislatures bearing the appearance of law constitutes the law of the land. The Constitution of the United States is a supreme law of the land, and any statute, to be valid, must agree. It is impossible for both the Constitution and law violating it to be valid. One must prevail. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose. Since unconstitutionality dates from the time of its enactment and not merely from the date of the decision, so branding it. An unconstitutional law in legal contemplation is as inoperative as if it had never been passed. Such statutes leaves a question that it purports to settle just as it would had the statute not been enacted. Since an unconstitutional law is void, the general principles follow that it imposes no duties, confers no rights, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no acts performed under it. A void act cannot legally be consistent with a valid one. An unconstitutional law cannot operate to supersede any existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. So that's really important to understand what that says. The very last sentence is very clear. No one is bound to obey an unconstitutional law. And I'm going to prove to you in the next couple of minutes that Kate Brown's executive order over all this COVID closure and shutdowns and lockdowns is, in fact, unconstitutional in at least 9 different places of our Oregon Constitution. So let's go ahead and let's begin. I'm going to be flipping the camera back and forth so that you guys can see exactly what I'm reading. What I put up there is parts of the Oregon Constitution straight from the state's website. So we're going to start off with Article 10, subsection A. Article 10. It lays out the duty of the governor and the government when an emergency is declared. You can see that in Section 1, Clause 2, public health emergencies are enumerated in its authority. I've attached, okay, so we'll back off of that. I'm reading basically off a letter that I'm sending out to state representatives, county commissioners, and sheriffs. So bear with me as we work through this. So, as you can see in the highlighted category there, D, public health emergencies are part of the state's constitutional delegated authority to manage. And so we're going to move on to the next section. So at the time the governor invokes the provisions of this article, the governor shall issue a proclamation convening the legislative assembly. That's very important. That is item number one that the governor has failed to do and has failed to adhere to our Constitution. Okay? It's super important that you understand that she has an obligation to do that because why? The people of this state demand representation, right? Not by just one person, but by of all the people that we've elected to govern for us. So that's violation number one. We're going to go on to violation number two. In the same article, X10-A, we can see that there is a termination clause to the declared emergency that Kate Brown has put out there. You can see in the highlighted areas that the termination of operation of this article, the extension by legislative assembly, except as provided in this subsection, the provisions of section 1 to 5 of this article, once invoked, shall cease to be operative no later than 30 days following the date the governor invoked the provisions of section 1 to 5 of this article. There's violation number 2. This started in March. We are running on 9 months of abuse and unconstitutional action. So there's our second violation. The third violation is prior to the expiration of the 30-day limit established in the subsection, the legislative assembly may extend the operation of sections 1 to 5 of this article beyond the 30-day limit upon approval of 3/5 of the members of each house. We have no legislative assembly convened, and they have not extended anything at this point. So every single extension beyond the 30 days that this executive order has claimed authority to is number 3, our third unconstitutional act. Okay? Now, we continue on to subsection 5. The governor may not invoke the provisions of sections 1 to 5 of this article more than one time with respect to the same catastrophic disaster. So there you have it. We have 4 clear violations of one single article in our Constitution. I'm going to flip this around again so we can talk a little bit. So that's 4 violations in just one article of our Constitution. All it takes is one. It takes one violation to make an executive order, to make a law, a rule, ordinance invalid. Because if it doesn't meet the standards of the Constitution, it cannot stand up to that scrutiny, just like our Supreme Court said that we talked about. So we're going to move on to the next article, which is Article 4, Section 14. So Article 4, Section 14, flipping back over. The deliberations of each house, of committees of each house, or joint committees, and of committees of the whole shall be open. We can stop right there reading it. You guys are able to look this up and read it for yourself. It's right there on the state website. What are we talking about here? We're talking about our state capitol being open when deliberations and we have a session of our legislators open. In December, we had an emergency session, and it was closed to the public. And why did they say it was closed to the public? Because of COVID, because of this executive order gave them the authority to do that. That is false. You can see here that it is, without exception, supposed to be open to the public. This is our 5th violation that this executive order does to our Constitution. So let's move on to the next. Article 3, Section 1, separation of powers. This is a big one. This is where a mass violation. She's violated our Constitution multiple times, claiming the authority that a single statute gives her. So let's talk about what this says. The powers of the government shall be divided into 3 separate branches: the legislative, the executive, including the administrative, and the judicial. And here's the important part. And no person charged with official duties under one of these branches shall exercise any function of another, except as in this Constitution expressly provides. I can tell you right now, I have yet to find anywhere that gives the governor the authority to write law at her leisure. So let's talk about this. Revised Statute 401.192. All rules and orders issued under the authority conferred by the beginning, basically the declaration of a state of emergency, shall have the full force and effect of law during and after the declaration of a state of emergency. All existing laws, ordinances, rules, and orders inconsistent with ORS 401.165 shall be inoperative during the period of time and extend to such period of time and to the extent such inconsistencies exist. So this is really a broad statute that violates our Constitution. It gives the governor the ability to branch out outside of the executive authority. The three branches of government exist for three separate purposes. The legislative branch creates law. The executive branch executes the law. And the judicial branch makes sure that the law is applied when accusations of it being broken are there to ensure due process, basically. What Brown has done here is she's gone from her executive authority of executing the law into the legislative authority of writing the law. And we'll continue on with this to understand where these breach of contracts are. So by her writing this executive order saying that her rules have the force of law, claiming that this statute, 401.192, has the authority to do so, is our sixth violation of the Constitution by this executive order. It's important to understand that when the legislature wrote the emergency declaration powers, that they understood that back when the very first article we looked at, Article X-A, that they would be convened and they would be the ones writing the rules and the laws. That's very important. As you read through sections 1 through 5, explains that. It explains that the legislature convened. Their duty is to come in there and write rules and laws needed to remedy the declared emergency. So they never intended for the governor to use that authority. It is very important to understand that, and as we continue to move forward. So we're going to flip back around here, and we're going to move on to the next aspect here. Okay, so the authority exercised under here may be exercised with respect to the entire territory over which the governor has jurisdiction. Within the Declaration of Emergency clause in the Constitution, it says that the emergency declaration must be the smallest area necessary. The smallest area necessary to remedy the situation. So when the governor takes entire counties, especially out here in rural Oregon, entire counties and puts them in her extreme danger declaration, it's nonsense. Because if you look at the communities like Brothers in Deschutes County, and let's look at Deschutes County for instance, because it's probably it is the biggest, highest populated county east of the Cascades. Bend has a huge population, which very well may be in extreme risk according to the governor and her made-up rules. But what about the town of Brothers, which is 45 miles east of Bend, that only has 50, maybe 15 people that live in it, or any of these other little towns that exceed out in rural counties? They're not under extreme risk at this point, and they shouldn't be lumped into that category. So she's violated that as well too. Okay, so where are we at here? So we're still going through Oregon Revised Statute 401.192. The power to the governor shall continue until termination of the state of emergency. The powers granted to the governor may continue beyond the termination of the state of emergency, shall be terminated by proclamation of the governor or by joint resolution of the Legislative Assembly. That's one thing that's being missed here. Again, we have no Legislative Assembly able to convene to decide if this emergency shall be terminated or not. It is left to the hands of one person. This entire state, our entire Republic of Oregon, our Republican form of government is being usurped here by one person. So here comes our next category that has been subverted by this executive order. Article 1, Section 26. No law shall be passed restraining any of the inhabitants of the state from assembling together in a peaceful manner to consult for their common good, nor from instructing their representatives, nor from applying to their legislature for a redress of grievance. Her order of nobody gathering in more than 10, 25, 50 people, wherever we're sitting at right now, violates this article of the Constitution, right? She is keeping us from coming together to decide what is best. Why? Because we are a self-governing society with a representative form of government. And when we can't come together to consult for our common good, there is no way we are going to be able to instruct our representatives on what we consider to be the common good. And then we cannot even have a legislature to redress our grievances. There's nowhere for us to go with our grievances at this point. So all three aspects of this article have been subverted by this executive order. So moving on. And here's something that is very important here. This is where article that 401.192 revised statute absolutely is invalid to this Constitution. It has to be declared a unconstitutional statute. The operations of laws shall never be suspended except by the authority of the Legislative Assembly. Very important there. Except by the authority of the Legislative Assembly. The Legislative Assembly did not suspend any rule according to all rules right here, right? All existing laws, ordinance, rules, and orders inconsistent shall be inoperative during the period of time. The Legislative Assembly did not write this executive order. The governor did. She has no authority to violate Article 1, Section 22 of our Constitution. This right here is a very clear, defined, definite violation that standing alone by itself would make this executive order unconstitutional. So I hope you guys are taking grasp of what we're talking about here. And we're going to continue on. There's more. Article 1, Section 21. No ex post facto law or law impairing the obligation of contract shall ever be passed, nor shall any law be passed, the taking effect of which shall be made it dependent upon any authority, except as provided by this Constitution. So let's talk about what that means. So for our restaurants and businesses, your licenses that you bought and paid for are a contract with the state. And what this says is that a contract may not be changed midstream by one party without the consent of both parties within that contract. So basically, the governor coming in here and saying that you have to be the weaponized tool of the state. You have to enforce this mask law because the law says so. We are changing your contract. It's unlawful. It's unconstitutional. Okay? And then on top of that, she is creating law that she is taking effect upon a contract, upon a people, that she doesn't have the authority to do that because the Constitution doesn't give her that authority. Our branches of government, the legislative, executive, and judicial, article very clearly defines that the governor cannot make law. That is not her job at this point. So she's violated this article as well. So moving on. Equality and privileges and immunities of citizens. No law shall be passed granting to any citizen or class of citizens privileges or immunities which upon the same terms shall not equally belong to all citizens. So I ask you, business owners, Walmart, Best Buy, Home Depot, all being open, allowed to have as many people in the store as they deem necessary, touching, looking, walking through their stores without any kind of guidance, and then you forced to close, forced to only serve takeout, forced to reduce your occupancy by 75%. Does that sound like that fits into the definition of this article? So no law, the very first two words are super important. No law shall be passed granting any citizen or class of citizens privileges or immunities. Home Depot, Best Buy, Walmart all have privileges and immunities that you do not have according to this executive order. I've lost count at this point on what number of violation that we are on, but we're getting close to the end here. I want you guys to understand. Now we're going to talk about our churches. Article 1, sections 2 and 3. All men shall be secure in the natural right to worship Almighty God according to the dictates of their own conscience. Right? And then the second one, freedom of religion, freedom of religious opinion. No law, again, there's that, no law, shall in any case whatsoever control the free exercise and enjoyment of religious opinions or interfere with the rights of conscience. This executive order has violated both of these. They've closed your churches. They said that you can't be there without half of your congregation or a portion of your congregation. You have to do this, you have to do that. Those are laws. And as you can see in section 3, no law shall in any case whatsoever. That means not in a state of emergency, not in a state of non-emergency, no law in any case whatsoever shall control the free exercise or enjoyment of religious opinions. So the closing of your church is completely unconstitutional. I believe that's 9, possibly 10 separate cases of a violation of our Oregon Constitution. So I really would like for you guys to take this information and really address it at this point. I've only talked about our Oregon Constitution here and one very unconstitutional statute. As we break down this executive order, the statutes that she claims gives her the authority, we can break down and go see. For example, she uses 401, the whole chapter of 401, the chapter 401 in the revised statutes. Its intent was to help manage and mitigate states of emergencies, natural disasters, specifically floods, fire, earthquakes, tsunamis, things like that. She has basically taken the authorities given in 401 and cherry-picked very specific statutes that she's using to trick the people of this state into thinking that she has the authority to do this. Okay? Chapter 433 is specifically written for public health emergencies. Yet, she doesn't apply all of the regulations and statutes within that chapter in her executive order. Specifically, she's ignored that chapter 433 says that there is a 14-day limit to a public health emergency. Where is that? 14 days was a long time ago, guys. I was still back in March 2020. So we are talking about massive violations, massive misuse of statutes, massive abuse of power in this single executive order. So I hope you guys take this information, share it with your friends, share it with your family, share it with people you know that own businesses. I've put it together in word form here. I'm happy to share it with you. Take it to your Board of Commissioners. Please take it to your sheriff. Tomorrow, I have a meeting with our Board of Commissioners and our sheriff to present this information to them as well. So I hope it is useful. I hope that you can understand that even our Supreme Court has said that an unconstitutional law has no force. It is null and void. And we, the people, have to let each other know this. We have to share this information with each other. We have to share this information with our elected officials. Just like in Article 1, Section 26. We have the right, we have the duty to assemble for our common good. We have the right and we have the duty to instruct our representatives. And we have the right and we have the duty to redress our grievances with our legislature. All of that is being blocked right now. All of these things that we've talked about, our churches are being abused, our businesses are being abused, our people are being abused. And this is a way, this is a path to restoration, to getting away from those abuses. So I hope this has been helpful. If you'd like to reach out to me, you can email me at peoplesrightsoregon@gmail.com. That's peoplesrightsoregon@gmail. I will send you a copy of this for you to use. You can go through it, you can adjust it, you can make it specific for you, you can make it specific for your county commissioners, you can make it specific for your sheriff. But please, we have the obligation to correct an out of bounds and unjust government. Our Declaration of Independence said that, let me get it right here, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, those that we've just talked about, that among these are life, liberty, and the pursuit of happiness. And here's the important part, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Our Constitution is our consent to be governed. And when our government does not follow our Constitution, they are, by definition, in the Declaration of Independence, an unjust government. And we have every duty and right to correct that by whatever means necessary. Article 1, Section 1 of our Oregon Constitution says that when all men form a social compact, they are equal in right. That governments, just like here, are derived from the consent of the people, and we have at all times a right to alter, reform, and abolish as we deem fit. If our government will not correct itself when it's out of bounds, it is our duty to correct it for them. Not for them, but for us. Because we have no obligation to consent, adhere to, or even follow an unjust government. Anyways, I've taken up enough of your time. We're running on about 30 minutes. I know it's a little bit long, but this information is solid. We're looking through it. Share it with your friends, your neighbors, your business owners, your community. And if there's anything that I can do to help, I'm happy to come to your area. I'm happy to come to your community and present this openly, answer questions, and help you guys find the courage to take your life back, to take our communities back, to take our businesses back, and re-engage in what life is supposed to be. So God bless you guys. My name is BJ Soper. I'm the state assistant in Oregon. If there's anything else that I can do, like I said, you got my email address. Please feel free to reach out, and I'll do my best to help you. So you guys have a great day. Share this information, and let's take our state back.